Members are free to seek legal representation. So when we say, before you take the floor, I think let's not be misunderstood by anybody that the committee is infringing the Constitution. But we are not denying anyone legal representation, including SIKHALA and Ndere. They are entitled to seek legal representation, but only that the choice of Honorable SIKHALA is their lawyer. Whilst the same Constitution underlines the right to legal representation, the same Constitution talks of limits to those rights also, if they are on reasonable grounds. In this case, that is the position of Honorable SIKHALA. You have all the rights, as you are aware. Beyond this room this afternoon, that you are entitled to, even your members, your clients are entitled to, and they can proceed as such. So that's the ruling, that Honorable SIKHALA is disqualified.
Yeah, Mr. Chairman, the right of reply.
It's like we now have to listen to the ruling. But you have other rights outside this room. But that's the ruling.
No.
So you as a good lawyer,
Mr. Chairman,
I don't want to argue beyond this point.
Mr. Chairman, you indicated something that has offended me as a constitutionalist, that there are certain rights that are limited. And you did not give me reference to any law, but it was your mere say so. In terms of section, the rights that are limited, Mr. Chairman, are enunciated in terms of section 86.
I think we have a problem, Honorable SIKHALA, respectively, the honorable member, respectively, citizen lawyer, you've been winning some good cases. And I think
that's why we are trying to build that.
The terrain now, where we are now going, itself, it's outside any legal procedure. That's a problem.
No, but the issue, Mr. Chairman, which you must deal with.
I want to respect you.
You cannot deny my clients the right to legal representation and proceed with these proceedings in their absence. Secondly, without the legal representation.
Honorable SIKHALA, look, we all those issues.
No, but
for this committee, I think we have ended so that if this debate does not aid anything.
It does. Tomorrow, after giving full instructions to my lawyers for them to come and represent them, I can agree. Not that you can proceed when my clients are not represented.
I think my committee needs another 1 minute now.
Yes.
Because of this proposal that we have made.
Do your 1 minute.
This proposal that we made, I think
do your 1 minute.
May see like I think we can converse. Yes. I don't even need to. But we need to debate that. That's the right. They can be brief.
Yeah. So we can. I briefed them overnight so that they are well acquainted with this case. Then tomorrow they'll come.
That's the Chinese business about that journey. All I can say is that members, you don't need to break on this one. It's a straightforward one. It's a straightforward one. That this is done. We agree with your proposal.
We
agree with your proposal.
So tomorrow what time, Mr. Chairman?
You are not supposed to be working. Right. You will not appreciate that this is a legal process, which should always adhere to principles of the law and the principles of natural justice. And as you go, certain may have to be moved in the interest of justice. Mr. Goddard was supposed to have presented his side this afternoon, and probably done. Mr. Goddard will appreciate the issues that are being reasoned, they are reasonable, they are lawful. So we are now pushing everything to commence tomorrow morning instead of this afternoon. It means we only come in tomorrow at 10 when we start. So, yeah.
Before. The chair, in his introduction, mentioned firstly the complainant and secondly the respondents. That denotes an adversarial system. As that denotes an adversarial system to be employed by the committee, we are seeking the following from the honorable members of the committee. First of all, are we going to have...
Sorry, I think we may address in too detail, take a lot of time, on matters that are not even agreed are going to be part of the process. I think at this stage, just ask a question. Is this adversarial or what? Please tomorrow give us the start.
All right. The first aspect is if the proceedings are adversarial in nature. The second aspect is whether we shall be employing an evidence leader to lead Mr. Goddard. For certainly the committee cannot sit as an adjudicator as well as an evidence leader. The third aspect is...
Sorry, on this one there is no problem. We'll have the legal counsel of the parliament. I just want to, some of the things are disposed of immediately.
No,
the legal counsel of the parliament will do that.
Will be the evidence leader.
Yes.
Thank you very much. The other aspect that we intend to find out from you was a written expose of the factual allegations vis-a-vis the adjudication's objective. Are we finding guilt or otherwise? Of corruption?
That, again, we will answer you tomorrow. I think we are very clear on that one.
Indeed. No, the introduction that we have been given is the one that has created an issue for us. The inquiry by Parliament relates to whether the report is going to be a report of finding of guilt or otherwise. That is all that we need in this particular juncture.
But we have a mandate.
Indeed.
We give the mandate.
Honorable Samka, you are not the chairman.
I'll move with you.
Yes.
We will polish it up tomorrow, but we're aware that we've already exchanged notes from ourselves, the Goddard's team, and yourselves.
Indeed. The reason why I say so and why I would want to flesh that out, you will notice that there has been a previous procedure in terms of these standing orders in respect of the Bennett matter. And in that particular instance, there were charges which were clear because at the end of the day, at this particular...
Sorry, let's proceed tomorrow. The Bennett challenge, that process does not apply to the Constitution changed a few things with regard to that process. So the Bennett's case, the proceedings under that case cannot be quoted verbatim with regard to this case because the Constitution did amend some of the... So the way we are proceeding today, we cannot proceed the same way. I just want to... You are a lawyer, when you study again the Constitution has amended those procedures.
I'm talking not about the Constitution alone, but actually the standing orders and parliamentary privilege that is there that supersedes the Constitution and was confirmed by the Supreme Court and our Constitutional Court that can have an adverse influence on my client. So I need clarification because at the end of the day, the manner in which we will proceed would make me cross-examine him for more than 2 or 3 days. So all I'm looking for is a summary. That is all.
Yes.
It's only the honorable question.
Thank you very much, Chief. I think that it would be best if council are allowed to raise all the preliminary issues. We take note of them, then we deliberate upon them as a committee, and then we give an informed response. So I'm going to propose, Chair, that we allow council for all the honorable members to raise any preliminary point they wish to raise. We take note of them, then we deliberate on them, and
then inform them of the position when we proceed to.
Thank you very much. I'm being very kind to the council. I'm actually being very kind. Sometimes actually assisting him to go do research in on this one position. And when he says, the leader said, we already have. I don't need to say, go ahead. Then he can come tomorrow and say, no, this is better now. We are not happy with that arrangement. Council of Parliament, so that we don't ambush them tomorrow. It's Council of Parliament. Then they can come and say, no, we don't want this process. Council of Parliament will want to lead. So I think that's favorable to him. He's now aware and prepared for it. The Bennett case, I should believe I was right, because I'm aware that if you really over-rely on how the Bennett case proceeded, we may get it wrong. We should be aware that that was amended also. So there are amendments to that. And we may not fully rely on the Bennett case. But are you, I see someone taking the floor before you finish?
Yeah, I just want to interject.
But no. You're in the interjection, or you're in the interjection.
He is concerned.
Yeah, but the way we do it here is not the way you are proceeding. You just stand up and switch on the mic and then you are, no. We have to do it. No, Mr. Lawyer, we want you to follow procedure correctly. It's done here, but we don't do the way you've done it. You go back, sit in the seat, then you ask for the chance we allow. No, Mr. Lawyer, we don't want you to proceed like that. Respect this committee. We respect you. That's why we allow you in. We respect this lawyer. We respect you. We respect you. Take my orders. We respect you. I'm here to give you orders. Sit down.
We apologize.
Thank you. Are you through yourself?
Yes, I have taken my senior in my profession to suggest something which I think is agreeable. We would want to raise invoicing for our preliminary issues so that we can have a technical.
Thank you, but mind you, we are proceeding tomorrow at 10. So these are very many issues. Okay, if they would come in before 10, that better.
Yes.
I think we will agree as a committee to meet you just before 10, so that we look at those preliminary issues.
I have no problem. The right of an advocate is the one of the slaves.
No, we have no more slaves. Thank you.
Mr. Chairman.
Please, Rascal.
No.
Can you just respect what we concluded?
No. A request for me to be able to give.
No, Rascal. You are a friend of this committee by operation and by promotion. You are a friend of this committee, Honorable Scala. You don't antagonize it.
It's a polite request.
No, don't antagonize. Do it through your other lawyer. It's fine.
No.
You are a smart lawyer. Do it through the other lawyer.
No.
Stand up and speak.
No, Mr.
Please.
Chairman.
You are now interfering with the process. It's unfair. You know this thing is Honorable Scala.
Chairman, if this is the way you are going to chair this committee.
We want your integrity as a good lawyer to be upheld all the time. And technically now, they don't have to him, he can stand up and say something. Lawyer, goodbye.
Thank you, Chair. I understand that before we started, everyone else was introduced. Each union confirmed. All the participating parties were introduced.
I didn't understand the question, but we will proceed.
I'm saying I understand that every participator in these proceedings was introduced.
Not who was introduced. They introduced themselves.
Thank you.
There's a difference.
Thank you. Now that everyone is introduced, him or herself, we hear there's a new party that you are now saying we believe in evidence. Is that correct? That person has not been introduced, or they have not introduced themselves?
Okay, good question. That's what we hear. Take a seat.
Thank you.
Take a seat.
Perhaps I thought you could allow me to raise all my issues and then respond.
Okay. There are certain issues that want us to speak. Yeah. Anyway.
Also, perhaps why I'm saying so, we want to raise issues that is so that when we come tomorrow, we don't start to raise new technical issues without this matter proceeding. That is where we are coming from. It's not that we want to unnecessarily delay. We want the matter comment on the merits. So when you raise all these technical issues today, so that once they are ironed out, the matter can then proceed on the merits. I'm sure that's why he stood up. That is perhaps why he also that will be used in these proceedings for the witnesses. So that we don't have a witness who hears the evidence of another witness and they go and prepare his or her own statement and then come here and say, I now want to testify. This is my case. Obviously, that will impair justice.
So, just clarification. You seem to be raising two issues. One, complaint, Mr. Gordon. That's where everything emanates. That was shared with all the parties. They confirm that what Mr. Gordon submitted was shared.
Thank you.
Unless you didn't receive it.
Thank you. Let me say something. Perhaps Mr. Honorable Zamkange and Honorable Bones. For the sake of progress, I would want your assistance in this case so that we progress. But basically, this is what I'm saying. We need to commence and proceed. It follows then that when we receive the statement for all these witnesses, then I'm going to receive them so that we go through them. We cannot receive one and then say we are starting because we have one. Then the other one goes and prepares another statement, and you receive another one, and you go back again and start to receive further statements from witnesses. What we request is the statements for all the witnesses who are going to testify beforehand. That then follows that if you are saying want to comment tomorrow, when we don't have those statements, again, it affects our time. Can we do tonight and go through them tonight and tomorrow come and start?
Go ahead.
So it then follows that we perpetrate injustice. Everyone here, including ourselves, if you want to take that course, this is what I suggest in my view. Wrong or correct, it's a proposition that there's no harm. Why not give you?
Myself with the submission of my learned brother and disassociate myself with the submission that we've been finished with the statement. Just to add that it will not be proper and in the interest of justice that we proceed without the statements of the witnesses to these proceedings. I understand that there is evidence to be laid from Dr. Mangunja, Tundia, as well as Dr. Stay, if I'm correct, David Stay, my apologies. So if we can be finished with those, I'm sure we'll be able to proceed well, as well as with respect to the rights of the accused person before this committee. That will be all, Mr. Chairman.
You give us 5 minutes. That is how it's 5. After 5 minutes, that's walking. After 5 minutes, just come back. That's walking. Yeah. Then one fast. Walking. Now it's what?
It's not 26 past.
No. It's 18 past. 18 past. 18 past to come back. 18 past to just come back.
The chairman of the privileged committee has disqualified you to represent your clients. What's your reaction to that? And what?
No, this is a miscarriage of justice. My clients have the right for them to hire a lawyer of his or her own choice, and I was their legal practitioner, and I was entitled for me to represent the interests of my clients in this matter. So we have noticed that we have managed to make sure that these proceedings do not proceed today, and also will take over from tomorrow to see how we are going to proceed.
But going forward, what are you going to do, considering that you feel that your rights have been violated by this committee?
No, specifically the issue which is here is that these people seem to already have a predetermined outcome of this committee. So specifically, what we are going to do is that we are going to make sure that the rights of my clients are respected and that they are going to get full legal representation by a lawyer of their own choice.
So are you if you're not going to be there in the committee in the inquiry, does it mean that you're going to take a legal action as well?
What we are going to do is that, like what we indicated
committee?
earlier, is that we are going to make an urgent chamber application in the High Court for the stay of proceedings, that these proceedings be stayed until the determination whether I've got the right to represent my clients or not. I have just conversed with my clients now. They are so depressed that the committee is denying them the right of a lawyer whom they have chosen to represent them to appear on their behalf. So I've already liaised with them, and they've given me instructions that I must go ahead by making an urgent chamber application in the High Court for stay of proceedings until they have made a determination whether there is conflict of interest for me to represent those two honorable members of Parliament or not.
You've actually raised concern that you have not been furnished with the proper details and adequate...
No, what is here is that, you know, that's why they have tried to quash my submissions when I have warned beforehand that they must not transform a prestigious parliamentary privilege committee into a kangaroo court by going ahead with the proceedings without finishing the respondents with the complainants papers. There are no papers for one called David Stein, who is said to be a witness in this matter. There are no papers from Dr. John Mangunjka, who is going to testify on this committee. There are no papers also from Tundia, which are very critical for us to be able to represent our clients, to know the nature of their allegations against our clients and so forth. So specifically what is happening is that this committee must not be used for political purposes. It must be able to dispense justice. But their failure to uphold the rule of law and constitutionalism has clearly demonstrated that Parliament needs to reform. You have noticed there are 5 Zanu-PF persons and 1 MDC. I am representing 2 members of Parliament from my party, and they have instructed me to represent them. So specifically it's clear vanhu ava chavari kuita ndechokuti vari kuda kudzvanyirira ma-MP maviri okubato re-MDC vanga vashara gweta ravo romumwe wavo woku-MDC kuti auye azomirira zvido zvavo panyaya iyi. So chavava kuita panapa ndechokuti chikwata cheZanu-PF chishanu changa chiri pakona paya ndio charwa vagonese nyange kuri kuti vazama kurwa vari vega, but vakurirwa nokuti chikomiti chinototaridza kuti chine predetermined outcome already on this case, because we know they've got issues with Temba Mliswa which they want to solve using these subverted parliamentary proceedings. I know they've got issues nana chikomba the faction kupati kwavo which they want to use this committee to solve. So specifically their interest is pure and simple. They just want to use this committee to sink other members of Parliament. No, we are going to see the way forward. Already I have liaised with my clients. They've told me that we must make an urgent chamber application in the High Court for stay of proceedings until the High Court has made a determination whether there is a conflict of interest for me to represent these clients or not. Basically, you have noticed it. They have called us for this tribunal, saying that the proceedings are starting today. Specifically, the proceedings at every tribunal or court is that a respondent or an accused person must be furnished with documents alleging the issues a person is facing. We have not received anything. We have got absolutely nothing. No statement from David Stein, no statement from Tundia, no statement from Dr. John Mangunjka, and they want to start proceedings. So that's why I have warned them. They must not transform a very important parliamentary portfolio committee into a kangaroo court. They must be able to follow the rule of law and constitutionalism. We need those papers, and without those papers, how can we proceed?
Sorry, Honorable SIKHALA, it seems that the chairperson has made it very clear that this committee is going to continue tomorrow, whether the papers have been furnished.
No, it can't proceed. You know, the members of parliament are being represented with lawyers, and some of the most brilliant lawyers in this land. You saw Advocate Juarara is here. I don't think he would allow the proceedings to continue. Well, we are not finished with the papers that are for us to be able to understand the nature of the allegations our clients are facing. I don't think he will be able to accept that. We will not accept to appear before things that are operated in a kangaroo fashion.
So there we have viewers speaking to Honorable SIKHALA at Parliament, where he is saying that he's going to be approaching the courts for stay of execution.
Anotanga kuti mhosva yake yaari kupomerwa ndei nanhasi hatisingaziva kuti mhosva chaiyo then patatanga kutanga kunzwa mashoko asina kunyatsogara nesu zvakanaka. Tanga kunzwa kunzi pana complainant in terms of which procedure. Toda kuziva kuti chanyatsomuita kuti auye pamberi peparliament chii chaari kuda kunyatsokutaura. Kana pazoitwa nyaya yacho hapana yatinoti pachirungu ambush kana tiita proper yes. Hapana chinhu chinonzi ambush. Tinofanira kuti kuva mapepa ese anzwisisa nyaya yesu tozopindura taziva maitiro avari kuita senge vakupenengera yatinoti acriminal case kana kuti munhu ane mhosva, asi matems avari kushandisa ndematems emu-inquiry. Vatoda kunyazoziva kubvira pekutanga kuti tiri kuita here atrial kana kuti tiri kuita inonzi inquiry. Zvakasiyana pazvinhu paviri. Painquiry vanhu vekomiti vanenge vachida kunzwisisa kuti chii chakanyatsoitika pakupomerwa mhosva pamamembers of parliament aitwa apa, handiti? Asi zvatakunzwa zvichiitika takuita senge vakutopinzwa pachipiyaniso kuti vatiudze kuti mhosva muri kubvuma here mhosva kana kuti. Saka ndo zvatiri kuda kubvunza kuti to plead guilty or not guilty. Hatisi kunzwisisa kuti muda kuti tiresponde sei. Kana iri inquiry toziva kuti kana vanhu zvavari kuda kutaura zvii zvavari kuda kutaura. Saka ndo zvatiri kuda kuita switching over to English. The real issue is that we have been brought before Parliament, and Parliament is not entirely clear of what it intends to do, whether this is an inquiry or it is a trial. The two procedures are fundamentally different. They require a different manner of adjudication. So these are the issues that we intend to raise. Furthermore, as we were about to start, it became very clear that Parliament does not even have, is not even finished our clients with all the material allegations that we are supposed to be dealing with. As it is, if we are forced to proceed tomorrow, we will be doing so in violation of the Constitution, which is the right to a fair hearing. And what you need to understand is that Parliament is a law unto itself, technically, in terms of the fact that Parliament has the power to even convict and incarcerate individuals. So we take these proceedings quite seriously. And Parliament also needs to take these proceedings quite seriously by furnishing us with all the requisite material for us to defend our clients. As it is, we don't even know, is this an inquiry or is it a trial? So those are the things that we intend to clarify. Those are the objections that we are going to be raising tomorrow. As it is, I believe that
we don't get these documents that you're talking about, are you going to allow the proceedings to go on?
Well, if those things are not provided, then there are no proceedings. Then we will just have to get a court of law to declare it.
Thank you.
I know. Then they get which that is, don't worry.
SIKHALA is now proper with all the gymnastics that we went through. That this is only for those who are representing and those that are going to take a different position as an observer. That's okay. Yeah. So take another position, a bench for observers. Thank you. Thank you for your submissions, all the three lawyers. In this type of work, we are exchanging ideas. Each one should go away after this whole process more educated, even legally. So there's nothing bad with you telling, and you accept that, and the end point coming so that we enrich the process. And indeed, you are enriching the process, and that is what it should be like. There's no winning and shouting. On that, we should use proper language to yourselves, respective language, and you do likewise to the committee. Mrs. Howe, to my right, is the legal counsel yes, she will be the legal counsel for this process. She works for Parliament in the legal section. Mrs. Sinyao supports and supports the committee and ensures that records are taken. Mrs. Chongas is over there. She represents the clerk. As you are aware, all the communication to this committee is through the clerk's office. So the clerk's office is part of the process. The madam sitting in front of me, her sole duty is to ensure she records verbatim what transpires. The anyone of Mr. Mazani, him is also part of Sinyao. This is support staff, ensuring that everything is well organized, is well recorded, and well reported. The committee has accepted your request that you are finished with all the documents. That will be done now. But you should also confirm that you did receive some of the documents, especially those from, or specifically from Mr. Gordon. And we need to agree that you have received, all of you. You do have that record. Yeah, the affidavit from Mr. Gordon, that is your way of receiving. Yeah, it was a very letter that was inviting you to come for the oral hearing. So, okay, at least you have received. Before we proceed, can one team, one comment in the contrary, to proceed?
Yes, perhaps. Are we confirming by silence, or I'm made to believe that I received, my client received the affidavit, which is this one. But then it refers to copies of certain letters which are attached. That is paragraph 1, the last sentence thereof. Perhaps if we may receive those attachments. I do not know if there is any further evidence from Mr. Gordon other than this affidavit and the two attached letters that I can confirm.
Fine, that is taken note, and I can assure you there will be attachments included.
So basically, that is the testimony from him, which is this affidavit and 2 letters. There is no other documentation that.
Okay, I think that is clear. We will get them. Maybe that's the case with everybody. Is that the case with everybody?
Yes, thank you, Mr. Chair. You forgive me for this one, as you know the circumstances around the ending of the matter to me. I've been made to understand that we have not, in fact, been served with that affidavit.
Even the one that is showing us?
Yes, Mr. Chair.
We put a request in writing for you.
More witness. Okay, clarification. The letters were given to members of parliament, not to their legal representatives. So ask your member of parliament.
Thank you very much. Well, as you know, that I may not be the legal practitioner of choice for the two accused persons, so I may need to inquire with them if at all they were served with that affidavit, and if at all they are going to allow me to then proceed to handle the matter in question.
Yeah, I'm advised that they all acknowledge the receipts. But what they're missing are the attachments.
Thank you.
So we'll try to prepare that, even with your members.
Thank you.
Okay.
But we confirm what is missing in our file that
So the attachments.
for Mr. Gordon's evidence.
Okay. And then the rest of the witnesses, as you have requested, you will be given before you leave today. So that, I believe, is addressed. The proceedings are not unresolved. It's an investigation only. And don't relate it anyway to the famous Bennett precedent. The Constitution, the new Constitution does not empower Parliament to punish the way Bennett was punished. No, that power was taken away from Parliament. So all we do is to do a report, present it to Parliament with findings and recommendations. We end there. We don't recommend this one should be, or this one should now go, like it was done with Bennett. If anything, we end with simply debate in this house, but no punishment, I would say. Punishment is something else, not our committee. I think, unless I've left out something that is important for your purposes, I think this is the information is shared with you. Now, I want to plead with you that we need to proceed. Having given you the documents, can we meet tomorrow at 10? Can I proceed?
I was thinking, Mr. Chair, if it's practical, if it's really practical for us to be served with statements of 3 witnesses and then be able to proceed tomorrow as early as 10 o'clock. I don't think that is practical, and for the purpose of preparations of the matter, I don't think that time, there is enough time for us to...
Just to assist you also. It's not 3. The total is 8.
Yes.
Yes.
Now it being 8, now I don't think that is then therefore practical for us to proceed at 10. I think 10 o'clock will not be convenient for most of us in light of the nature of the case before.
I'm advised that we do not deal with all the affidavits one time. There is a schedule which you have interest in certain proceedings, not all. For example, in case may be 2. So if we follow the proceedings, we can study them as we go. Is that okay?
I would know, would there be any prejudice if we are to be informed of the witnesses that will proceed with tomorrow?
This letter was sent, it's because, as you say, you have come in a bit late into this thing, so you need to have some background. And we have Mr. Goddard, who will then appear at 10 tomorrow, followed by Mr. David William Stein, followed by Shepherd Tundia, followed by Honorable Chikomba. In fact, Chikomba was for Wednesday. And then Honorable Ndebele Wednesday, Peace Landa Wednesday, Honorable Meliswa Wednesday, 1500 hours. So Honorable Meliswa is coming at 1500 hours on Wednesday. Honorable Landa 14 days. I think Wednesday won't be affected with our change today. It is tomorrow only that will be affected. It means tomorrow initially, what will we take tomorrow? Yeah, we're going to have, yes. Tomorrow at 10, we're having Mr. Goddard. We'll be followed, and I think they have, and then we'll be period of time. Only those two tomorrow. No. So it's when, then after that, the 14th date is to be. That remains, okay. Yeah, the afternoon remains okay. So afternoon tomorrow is to be 14:30, then we break. So we start with Mr. Goddard at 10, followed by David Stein, which would be quite 11:30. Then afternoon 14:30, Shepherd Tundia. Then Honorable Chikomba is Wednesday at 10. Honorable 11:30, Honorable Swanda 14:30, Honorable Meliswa 1500 hours on Wednesday. So we believe you actually would have chance to time to be able to prepare. Since it's very well spaced. Mr. Goddard is coming in first time tomorrow, first at 10. You already have accepted the affidavits which you have today.
Yes, thank you. Since one name is missing from the list that you've just given me, what about Mr. Mangunju? Dr. Mangunju?
I think we'll again discuss this when he's coming. Yes.
Okay, thank you.
Yes, go ahead.
Thank you very much. Unfortunately, I think there has been a we're at cross purposes. Tomorrow, before the convening at 10 o'clock, Honorable Meliswa, under my hand, shall be filing preliminary objections to these proceedings.
Okay.
The clarification that the Honorable Chair has made further emboldens the Honorable Member. First of all, the aspect of asking for all of those affidavits. We are trying to avoid the possibility of collusion. Once Goddard testifies and another party testifies, there is the possibility of witnesses then tailoring their evidence to fit. So we want to be able to press anyone who comes before you so that we purge them of the desire or the suspicion of lying. For once they do that, I guarantee you, we will be suggesting for criminal charges for any person who comes and lies before.
You are now becoming a friend of the committee, because what you are saying is what we also, it's our spirit. All the statements are in a one. Secondly, when we commence oral evidence tomorrow to be done under oath, we actually have the Bible already with us. It's ready. It will be under oath. So we concur with what you are saying. It's very good. No one to lie. And we are with you on that point. And then as to the points that you raise tomorrow and the concerns, they are very clear and reasonable. Only that I would also share the requesting that this is an investigation. So you can also come up with proposals. It's how yourself Don't just criticize what you think, what you do. Don't just criticize. Come and say, no, we are here. The best way to get out the results and the evidence, why don't we proceed? We can even agree with you. So apart from just criticizing, we also propose a way that you think is comfortable, of course, which we are satisfied with, that it's just proper and give us stuff. It's okay, so come up with your proposals. As you are aware, the way we proceed, the procedure is not very much cast some stone somewhere. It is all within the rules of fairness and justice and all that. So within there we can play the ball within the boundaries of fairness and justice. So
Thank you, Chair. In respect of my client, the decision on whether or not to file anything technical will depend on the evidence that we receive. So ordinarily my client is the right to file. Should we find anything arising from the evidence that we receive?
I think we hear what you are saying. We are today, and then the secretariat raised the incident. What they do? You wait here, wait for the papers. No, lounge by the reception. You go to the lounge by the reception. You wait for the documents that you requested and know about reading. So I thank you. Good night. See you tomorrow at 10.
Invite. So, Advocate, you've indicated that in the event that any one of these people that are actually raising these charges against your client lies under oath, and then it's predetermined in the outcome that they've been lying under oath, you will press for charges, for criminal charges,
yes,
to court you right.
Yes, the crime is called contempt of parliament. It was somewhat reduced in terms of its ability by the Bennett case and the new constitutional amendments that came. But however, if anybody lies under oath, tells a mistruth, which we suspect is in this particular situation, they will be opening up themselves to the crime of perjury, which is aggravated by the fact that it is a lie to parliament, which in itself is a very grave violation, and in terms of the administration of justice, that person can face no less than 5 years imprisonment. So that is why Honorable Muliswa has demanded that he be given an opportunity to cross-examine the witnesses that come before him. The witnesses, once they are cross-examined, will be able to assess whether or not they have lied. So we intend to ask the report that then goes to the main house to have an aspect of fact-finding, whether Mr. Goddard is telling the truth, whether Mr. Goddard has perjured himself, and whether Mr. Goddard has actually brought the whole process of Parliament into disrepute.
In terms of the time span that you've been given to respond to the said allegations, I understand you've indicated that some of the paperwork you didn't have it as of now, but now you've been told that the committee is going to be continuing tomorrow. Do you feel you've been given ample time to prepare yourself to respond to the said allegations?
Well, in terms of the allegations against Mr. Honorable Muliswa, they're quite direct. We'll be able to prepare for them. Unfortunately, those are the lives of a lawyer. Sometimes you do not have sleep. But the real issue is that we need to be prepared for each and every witness that will come. We have been advised that not all witnesses will be deliberated on tomorrow, which is important.
but more critically, we are concerned about, personally for me, concerned about the allegations that were made in respect of Honorable Moliswa, which are quite silly. If I'm allowed to use unparliamentary language, they're quite silly in the sense that they need to be